Welcome to the seminar, The Proposals for Reform of Supported Accommodation. We're just at the beginning, and so we usually allow a little time for people to log on. But as I am giving a short introduction before the main speakers, I am going to crack on and start with my slideshow and introduce what the seminar is about and what we're going to talk about, on the basis that as it's an introduction and covering material that most of the people will be aware of, it won't be too much to start before everyone's here. If I start with slide 2. So what's going on is I'm going to say a little bit about the housing benefit background, where this all started. And then our main speaker, Georgie, is going to talk about the committee report and what's in that. And then finally, Tim Baldwin will look at the bill that's on its way through Parliament. So in broad terms, the seminar will be looking at the housing benefit background and where some of this stuff has come from, the perceived problems with the supported accommodation sector, and what the government intends to do about it. Next slide, please. Just to remind you, the source material, the legislation, it's quite difficult to find, so there it is listed for you. And I put at the bottom that there's a new housing benefit guidance specifically for this area, which will give you some insight in how decision makers are looking at this. Next slide, please. So I thought I'd just mention some terminology that's thrown about in the material that we're looking at. So supported accommodation, everyone will be familiar with that. It's worth reminding ourselves that it's to help residents either to live independently long-term or to move on to mainstream housing. And the list gives you an idea of the range of individuals that could come under this term. Next slide. So providers of supported accommodation, according to a definition within housing benefit, is that list. County councils, residents, and the basic idea is that they're non-profit making organisations. That's the basic idea, including private landlords in this area. Next slide, please. So there's a statutory definition. That's more or less all there is in the legislation. And the point is that if you come within that definition, then the housing benefit claim for that will not be limited by the usual caps for housing benefit. And the idea is that the rent levels for exempt accommodations need to be higher because of the extra expense involved in running such accommodation. Next slide, please. So housing benefit case law, there's a lot of it, but it's quite difficult to pin down what it's trying to say sometimes because it's so context specific. But the first point to notice, it's all about a housing benefit claim. So it's an individual claimant, though often the parties want to work out whether the scheme as a whole is under the definition. And then, a lot of controversy arose over the phrase on behalf of, because a lot of arrangements were joint ventures where support was being commissioned by social services or the NHS, and free bodies were involved, and that arrangement suddenly turned out not to be within the definition. And one of the consequences of that is that a line of cases developed where support could be provided directly by the landlord. Next slide, please. Out of all of this, another term arose, intensive or additional housing management. So this is not a legal term, but it was one of the ways in which some providers sought to bring themselves within the definition. And so this term could include things on that list which are not directly providing support, but indirectly. Next slide, please. Funding of care support and supervision is interesting because originally it was within the housing benefit scheme, and it was a court decision decided that it could not be within the scheme. So the government came up with an interim scheme where they allowed charges, and then they came up with a transitional scheme where they again allowed certain charges to be made within housing benefit. Next slide, please. And then eventually they came up with something outside of the housing benefit scheme, supported people program, and provided funding in that way. And the housing benefit regulations specifically excluded care support and supervision as an ineligible charge. But you may remember in 2010 onwards, funding to local authorities came under great pressure, and the supported people program was not ring-fenced, and gradually it all faded away. Next slide, please. So the current position, the direct care, it can't be funded, so it'll either be provided by the local authority commissioning it, or where it can't be provided by housing benefit, as I mentioned, so it will be through commissioning. The care provider might have surpluses, or they just levy a charge on the residents. Next slide, please. Specified accommodation, they had to create these categories because of when they introduced universal credit, they decided in the end that supported accommodation should stay outside of universal credit and be paid by housing benefit, and these categories do that job. So next slide, please. That should be the end of my slides. And now we come on to our main piece. Georgie's doing all the heavy lifting. She's a member of the Immigration, Community Care, Public Law, and luckily for us, the housing team. Might be of interest that she was involved in a recent case, Smith, which looked at government's reform of planning and the definition of gypsies and travellers. So here we are, another reform of the law involving planning. So she's ideally placed to have a look at this. Over to you, Georgie.
Thanks, Desmond. So as you say, I'll be covering the issues and recommendations outlined in the Levying Up Housing and Communities Committee report published on the 27th of October. The report really does make for grim reading, as some of the conditions it's describing are really disgraceful. And considering that the occupants of exempt accommodation are by definition vulnerable and in need of care, support or supervision, what we're actually seeing is that the worst of these residencies is exacerbating and exploiting the residents' existing poor physical and mental health. This goes beyond disrepair, and in some cases we have gangs, sometimes connected with landlords, targeting exempt accommodation, looking for vulnerable people to exploit. Now, I caveat this bleak picture by pointing out the limited data available to the committee, which I'll come on to, but the data itself really is symptomatic of the patchwork regulatory landscape covering exempt accommodation. Next slide, please. So following on from Desmond's outline of the background to this report and indeed exempt and supported accommodation, I've set out some key dates here for both the pilot scheme, which was launched by the government between September 2020 and October 2021, and the report itself. So the government conducted pilots across 5 councils to test enforcement measures to improve the quality and value for money in supported housing, which was backed by £5.4 million in funding. Then on the 17th of December, the LUHC Select Committee launched its inquiry into exempt accommodation. The evaluation of the pilots was published on the 7th of April, and this data played a big part in the committee's inquiry. The committee's final report on exempt accommodation was then published on the 27th of October 2022. Next slide, please. The committee sets out from the start of its report that its findings are somewhat limited, as there is currently no data nationally on exempt accommodation and no systematic collection of data. And this affects both how effectively quality can be monitored and how the government can guarantee value for money. I've quoted here from the report that due to the scarcity of data on exempt accommodation, the inquiry was, for example, unable to establish how widespread the very worst experiences are, either among residents or local communities. Next slide, please. This notwithstanding, the report did receive 120 written submissions, and although the committee concedes that those suffering the worst experience of exempt accommodation are more likely to engage in the investigation, there was lots of useful material in there. There were 3 oral evidence sessions, and I've set out the key members of Parliament involved here. And the committee also conducted on-the-ground research in Birmingham to hear directly from residents of exempt accommodation and neighbourhood and community groups affected by the considerable expansion of exempt accommodation in parts of that city. Next slide, please. Before outlining the issues identified in the report, it's important to bear in mind the justification for exempting some supported accommodation from locally set caps on housing benefit, and that's to ensure that vulnerable claimants of housing benefit are not prevented from accessing support by the higher rents in supported accommodation. And Desmond set out what allegedly causes those higher rents, and that includes the higher administration costs, higher insurance, the practice of not taking deposits, and indeed for providers to mitigate the risk of housing benefits being suspended at any time. So who provides exempt accommodation? Again, the landscape of providers is patchy, with the quality varying greatly between providers. Services can either be registered or non-registered, and commissioned or not commissioned. And we've seen that whilst housing costs are covered by the uncapped level of housing benefit, it cannot be used to fund the care, support or supervision element of the housing. So providers fund the care they provide through either charitable or commission funding, provider surpluses, or unless the resident is eligible for state-funded care package. Next slide, please. The report outlines several issues with the current framework, but I'm going to be focusing on these 7. So first, that is the quality of housing, the lack of a definition for care, support and supervision, the referral process or lack thereof, the limited regulation oversight of the sector, the position of domestic abuse victims, the residents being vulnerable to eviction, and the exploitation of the lease-based model of provision. Next slide, please. So, in light of reports of poor quality housing, the government published a national statement of expectations in October 2020. However, this document's only guidance with no statutory force, which only covers the accommodation and not the support element of supported housing. As an example of how appalling conditions are rife among exempt accommodation, Hull City Council found that 3.5 significant hazards were present in the places it inspected between April 2019 and 2022, with 62% of inspected properties failing to meet the Decent Homes standard. Numerous contributors described properties as cramped, dirty, damp, and potentially unsafe in a fire. And these are clearly inappropriate settings for delivering care or support with people, for people with support needs. Next slide, please. So that's the housing element, but there are also concerns with the care, support, and supervision element, which is, as we've seen, not defined in housing benefit regulations, but defined in case law. And I've cited there Bristol City Council and AW, which describes it as more than minimal. So as a result, there is no guarantee that the care, support and supervision on offer can actually meet the needs of the resident. The support on offer was reported as being sometimes little more than a loaf of bread left on a table, or a support worker shouting at the bottom of the stairs to check on residents. Many providers outsource the care and support element to managing agents that are profit making, thereby getting around the non-profit status requirement. They can often lack training and are inexperienced and unqualified to help people with varying needs. The report recommends in this regard a statutory definition, which on the one hand outlines minimum standards, but is flexible enough to avoid a strict one-size-fits-all approach. They recommend that one objective of the care support or supervision should include helping residents to progress towards independence and employment. Now, the government announced on the 17th of March a pledge to change housing benefit regulations to include a definition of care support and supervision and to introduce minimum standards for support, but this is yet to materialise. Next slide, please. So how do people end up in supported accommodation? While some people are referred into exempt accommodation by local authorities or from prisons, others respond to adverts, such as on Gumtree or Facebook. The latter group are often offered no assessment of their support needs and are then relocated great distances or housed alongside an inappropriate mix of residents. So, for example, we have instances where female survivors of domestic abuse are placed in mixed sex accommodation or with former perpetrators of violence, and those in recovery from drug addiction can find themselves living with people in active addiction or in the involvement of drug supply. The report recommends to address this that the government should standardise or strengthen the protocols around the referral process. It should assess how individual providers accept and decline referrals into their scheme, and housing officers should be placed into prisons to identify appropriate accommodation for prison leavers. Now, this is already in place in some prisons. Next slide, please. The regulation and oversight of exempt accommodation is frankly a mess, since there's no requirement for providers to be registered or accredited, and services may be either commissioned or non-commissioned. The regulator of social housing has oversight of those on the social housing register, but private landlords and non-registered providers are not subject to this oversight. This is the dominant regulator, overseeing roughly 57% of exempt accommodation providers. Councils can monitor the support provided by commissioned services, but they have no remit to apply the same scrutiny to non-commissioned services. The Quality Care Commission only has oversight where an organisation provides personal care as defined in the Care Act 2014, for example, people with learning disabilities. Providers with charitable status can be registered with the Charity Commission, and community interest companies might be registered with the Financial Conduct Authority or the Office of the Regulator of Community Interest Companies. But as a result of this complex regulatory environment, many providers fall outside the remit of any regulatory regime. And this system invites abuses, with some providers amending their structures and status to better bypass regulation or minimize scrutiny while reaping large returns. Next slide, please. Councils also lack control over the extent and spread of exempt accommodation, in part because of exemptions within the planning system. So providers of exempt accommodation that are registered with the regulator of social housing are exempt from house and multiple application licensing requirements, so HMO licensing. And by being excluded from the HMO definition, registered providers are also exempt from Article 4 directions. So that refers to Article 4 of the Town and Country Planning Order 2015. Article 4 directions give councils, if they choose to impose them, the ability to restrict the change of use of a property under permitted development rights. And where there is an Article 4 direction in place, a change of use to an HMO would require planning permission. But of course, these properties are exempt. No registered providers, non-registered providers who would otherwise fall into the definition of an HMO can also benefit from the loophole whereby a property with 6 or fewer residents living together as a single household, where care is provided, can be classed as a single household, thereby obviating the need for a HMO, again, avoiding the need for planning permission. Next slide, please. Thanks, Anusha. One of the main demographics being let down by the current system is victims of domestic abuse requiring support. Organisations with no expertise are targeting survivors of domestic abuse and their children and provide neither specialist support nor an appropriate and safe environment. Some survivors had experienced violence, harassment, and controlling behaviour by staff and other residents and were inappropriately housed in mixed sex provisions alongside perpetrators. Now, Part 4 of the Domestic Abuse Act 2021 and the Domestic Abuse Support Regulations 2021 define relevant safe accommodation and inter alia they expressly exclude bed and breakfast accommodation, and some of the existing exempt accommodation really is little more than just that. The report recommends that where a prospective resident of exempt accommodation is a survivor of domestic abuse, there must be a requirement that housing benefit is only paid to providers that have been recognised as having expertise and meet the standards set out in Part 4 of the Domestic Abuse Act 2021. Next slide, please. Despite the poor conditions in many of these accommodations, residents often avoid raising complaints either with the landlord or the councils as they are vulnerable to eviction. The present model creates a disincentive to work. Once the resident gains employment, they can lose access to some of their enhanced housing benefits, and they are then liable to pay rent set by providers. They can't afford private rental until they have a job, but they can't get a job until they move into a property with more affordable rents. In addition, providers often give residents a license agreement rather than a tenancy agreement. Licenses are the dominant agreement type among non-commissioned exempt accommodation. And this means that residents have fewer rights to bring forward complaints and protection against eviction. The report suggests delaying the point at which tenants in exempt accommodation become liable for paying rent when they gain employment, to allow a buffer period, and they can then secure alternative accommodation after rather than before starting work. Next slide, please. The last issue which raised particular concern in the report is the lease-based model of exempt accommodation, whereby the entity that owns the property is for profit and leases the property to a not-for-profit entity, which then delivers the management and care services, often through agencies. Because the landlord meets the criteria for uncapped housing benefits, but the owner of the property sits outside of those regulations, the uncapped rent can be pocketed as a disguised profit income stream. In favour of the lease-based model, it enables genuine supported not-for-profit providers to access the market where they could not afford to buy properties outright. However, it is often exploited by those whose primary objective is to make huge profits by driving up the base rent at the expense of the taxpayer. The report urges the government to set out how it will clamp down on those exploiting the lease-based model for profit and prohibit lease-based profit-making schemes from being set up. And this should include how it will ensure that there is full transparency over ownership structures and how income from housing benefit is being used. Next slide, please. In summary, the committee finds that the quality of provision of exempt accommodation varies greatly, and that the patchwork regulation has too many holes in it. So it recommends that the government should publish national standards with statutory force and give local authorities the power and resources to enforce these standards. create an accreditation scheme for providers, which should not be overly onerous or costly for providers to apply to, as several non-profit providers express concern about the burden of an application process. But this would ensure a valuable filter against unfit providers. The government should also provide burden funding to local authorities, and the report urges for the creation of a national oversight committee to address the oversight and regulatory issues relating to exempt accommodation. Next slide, please. The committee also recommends that the government should extend existing exemption, should end existing exemptions that registered providers have from houses and multiple occupation licensing, and address loopholes relating to non-registered providers with property containing 6 or fewer residents. This would bring them into the planning regime and give local councils greater control. Next slide, please. Finally, to address the dearth in data on exempt accommodation, the committee recommends that the government organise the collection and publication of annual statistics on the number of exempt accommodation claimants, providers and units, the amount of money paid out in housing benefits, and that the government should conduct a review of exempt housing benefit claims to determine exactly how much is being spent. I'm now going to hand over to Tim, who will look at whether and how well the Supported Housing Regulatory Oversight Bill addresses some of these concerns.
Thanks, Georgie. Before we let Tim set off on his talk, just do a little bit of housekeeping, just to remind everybody that these slides and the recording will be sent to them after the seminar finishes. And if questions occur to people during the talk, please put those into Q&A so that we have a chance to have a look at those and try and answer them at the end. You'll notice I didn't mention this during my talk, so we're going to let Tim get stuck with all the Q&A. You'll bear in mind that the recommendations and findings that were made by the committee are all their own, and we're not here to defend those. But anyway, we're passing over to Tim, who's a well-established member of the housing team. Many will be familiar with him. But just to remind you that amongst many of the things that Tim has done, he did go over a book on the Housing Act 2004, a practical guide. Many of the issues that were raised under that legislation seem to be coming up again in this area. So over to you, Tim. What is the bill going to do?
That's an interesting question, Desmond. What is the bill going to do? And what I asked Anusha to do is just go to the next slide, please. The peculiarity of this bill, which is called the Supported Housing Regulatory Oversight Bill, it's a private members bill that was introduced by Bob Blackman, who was instrumental in the Homelessness Reduction Act legislation. And its bill number, for those who are interested in looking it up, there is a link in these slides to it, is Bill 19, 20, 22 to 23, and it started in the House of Commons. So the plan is for it to, if it is to pass through the House of Parliament, to hopefully come in force or into effect prior to the next summer recess. And the long title of this bill is a bill to make provision about the regulation of supported exempt accommodation, to make provision about local authority oversight of and the enforcement powers relating to the provision of supported exempt accommodation and for connected purposes. So that's the long title. And the interesting thing, it was introduced to Parliament on the 15th of June 2022. So it is pre the publication of the Levelling Up Committee report. and it can be found in the link there when you get the slides. And what it doesn't do is quite match up with the recommendations of the Levelling Up Committee. Particularly, it doesn't mirror the recommendations completely that Georgie referred to, particularly in respect of the issues around creation of leaseholds in order to have exempt accommodation based there. So it predates the Levelling Up Committee report, and it's a private members bill. But this bill seems to be, to some extent, adopted by the government, and I'll come back to that shortly. And the bill comprises 14 sections. It's a very short bill, and it's broken down into subheadings for advice, strategy and standards, licensing, planning and homelessness, information and interpretation, and final provisions. So the key bits are within the 4 first parts of it. And the explanatory notes can be found in the link that I've incorporated into this slide. And the explanatory notes are created by the Department of Levelling Up Housing and Housing. So if we go to the next slide, please. So what is the mischief that this bill is aimed at? What is the naughtiness that this bill is trying to resolve? There's no single regulator for supported housing. That's one of the main problems. And when it's provided by a housing association, in the most case, the landlord will be registered with the regulator of social housing and will be subject to that regulatory framework. However, that regulator adopts what they call a risk-based approach to regulation and only focuses on providers with more than 1,000 units. So if you have a small provider with less than 1,000 units, it doesn't really focus that much on the regulation of that. The main concern that seems to have arisen is out of the lease-based provider. And that is where you have a provider who finds a landlord with an empty property and creates a lease for the purposes of setting up a form of exempt accommodation, where there are concerns about the standards of management and level of support. And from the crisis policy briefing paper that is in the link in the slide there, it's said to be associated with investors looking to maximize returns using higher rents permitted by exempt accommodation housing benefit provisions. So the concern is at its heart that you're getting people coming into the exempt accommodation sector who are looking to make a profit out of it using taxpayers' money without giving the appropriate levels of support and management. And also there's concern that that may introduce an element or permit introduction of elements of criminality and exploitation into the system. And also there are questions as to the adequacy of the regulatory regime. You will have seen from what Georgie said that it's quite patchwork. It's parts of it are unregulated. The regulation of some bits of it are just obscure, and that there's a lack of a dedicated funding stream to cover the support in respect of non-commission provision. That is provision that's funded by, not funded by a local authority. And as Georgie said, that in 2020, the government published a national statement of expectations, which set out its vision. And the pilots were in Birmingham, Blackburn, Blackpool, Bristol and Hull to improve quality, enforcement, oversight, and also value for money in the sector. What you're looking at is rental values, sometimes traditionally that have been £300–400 a week per resident. versus much lower rents if they were not in a supported environment. And there was, and the expectation is that these forms of accommodation are to be a short-term arrangement and focused on having people there short-term and not long-term. And various things have been published, including the evaluation of the report. And what I've done in the links there is given you the various statement of expectations and the evaluation of the pilots. The interesting thing, which is on the next slide, is the written statement of the Minister, which was 17th of March 2022. This predated both the production of the bill and also predated the report of the Levelling Up Select Committee. And what are the take-home messages from the Minister? Well, the government accepts that supported housing plays a vital role with the improved well-being and health of many vulnerable people, and that there's a commitment that supported housing is of good quality and meets the needs of the residents. And the government recognises it's important and has said that they're going to invest £11.5 billion in a much needed supply through their affordable homes programme. And in particular, the delivery of new supported housing for older, disabled and vulnerable people. So there's a government commitment to put a large amount of money into provision of supported housing. But here's the mischief. Here's the mischief. They're aware that a minority of landlords who charge high rents for poor quality accommodation and little or no support. So that's the concern of the government and many MPs. And what he says is that the government's intention, it was the government's intention to bring forward measures to put an end to unscrupulous landlords exploiting some of the most vulnerable in our society. So from this, I took it that it was the government's intention to introduce legislation and an act of Parliament to deal with this. Georgie has identified and Desmond has identified that there were issues around introducing legislation concerning housing benefit and other recommendations, but the government itself has not introduced any legislation as of yet. And what the government's other intention was that they had no intention of providing or penalising those providers who operate responsibility. And it says we are clear that the measures must be as targeted and proportionate as possible to protect supply of housing across the board. So you've got a clear idea from the Minister that there has to be a very careful balancing exercise here in terms of enforcement and running rogue landlords out of the business, especially those from the private sector, as it were, private landlords, but recognising that you don't want to damage the supply of this housing, and also you don't want to damage the delivery of new housing for older, disabled and other vulnerable people. So that this identifies the mischief, but this also identifies the potential problems that may arise. Next slide, please. So here are the other intentions that comes from the Minister. And one of the other things that is there is that to create new powers for local authorities in England to better manage their local supported housing market and to drive landlords out of the market. And also to change housing benefits regulations to seek to define care, support and supervision to improve quality and value for money across all specified housing provision. And just to preempt that question, the draft bill itself does not define care, support and supervision. It uses those same words, but the definition here will be within housing benefit regulations. And the minister says that the government will introduce any measures requiring legislation when parliamentary time allows. So there's nothing from the government as yet. And it talks about working closely with the local government sectors, providers, people with experience of supported housing, and to ensure that it's all fit for purpose and good quality, and that they aim to put in another £20 million for supported housing improvements. So those are all the words from the minister, and that was the 7th of March this year. Next slide, please. So where are we? What we don't have is anything from the government, but we have a private members bill that's got to the second reading. And you can see there's a Hansard report already, and I've not seen any amendments. And the draft act is a little bit peculiar. Draft bill is a little bit peculiar because it talks about extending only to England and Wales. And then when we look at the act, you'll see that it applies only to England. And because housing is a devolved function, if Westminster were to legislate in terms of other parts of the UK, England, Scotland, and Wales, it would have to get the consent of those legislatures. But it's viewed to be that it will come into force 2 months following the beginning of the date of royal assent. And the Act creates various powers from the Secretary of State, and the ambition was for it to be cited as a 2022 Act. So it does raise a question, given that this was started in June by a private members bill. It was followed on from the minister's statement. The government has not started, as far as I can see, on any legislative programme itself, whether we're going to get it in by summer 2023. It's a long way to go, and it's only just started. Next slide, please. So I do identify the contradictory statement that's set out in the explanatory notes, which is not a good start. And there's no evidence base outside of England. And what clause 1 does is create a housing advisory panel, and that's to provide information and advice in respect or in connection with exempt accommodation. And it could have a significant impact on the provision of supported accommodation and regulation. And it reports to the Secretary of State and other bodies in England. So this is an England-only Act. And what there is as a duty under clause 2.1 to play on local authorities to carry out a review of the supported exempt accommodation in their districts, and to publish a supported housing strategy for the provision of exempt accommodation in their district. So there's got to be a whole review by each local authority of what their supported exempt accommodation is. And the clause 3 allows the Secretary of State to publish national supported housing standards in England, and to set minimum standards in respect of the type or condition of premises used for the provision of supported accommodation, or the provision of care, support or supervision at supported accommodation. And such standards must be kept under review. So there's still a lot of work. Local authorities have to do a review, and the Secretary of State has to publish their national supported housing standards. So we're a long way away from that yet. Next slide. And what the Act does is create a new licensing regime. So clause 4.1 gives the Secretary of State the power to make licensing regulations, and that's in respect of the definition of supported housing in clause 12.2 and located within a designated district. Clause 12 is the meaning of supported exempt accommodation, but doesn't change anything from an existing definition. And it says that if at the end of the year of commencement the power has not been exercised, the Secretary of State must publish a report on progress. And the question will also be how this would fit in with not only HMO licensing, but there are also selective licensing regimes within the 2004 Act that a lot of local authorities have brought in already. And that is not really thought about either within this Act or otherwise. The only considerations are concerns about HMOs. And there's a definition of supported exempt accommodation, and it includes managed properties, refuges, and local authority hostels. And there are various powers of the Secretary of State in respect of exempt accommodation. Next slide, please. And there's a whole set of licensing provisions that I've set out in this slide, that is set out in clause 5, which I'll leave you to read because it's quite dense. And it's creating a whole new licensing regime that somehow mirrors the Housing Act 2004 in terms of application, appeals, and sanctions, including a database of rogue landlords and rent repayment orders. And also in terms of mechanisms controlling compliance with licensing and selective licensing regimes. Next slide, please. There has to be a consultation with statutory consultees before exercising the power to make licensing regulations, and that is set out under clause 6. And clause 7 places a duty on local authority in the exercise of their functions under licensing regulations to have regard to the national supported housing standards and any guidance issued by the Secretary of State. Next slide, please. And also it requires the Secretary of State to carry out a review of the effect of the licensing regulations on the type, conditions of premises used for provision of accommodation and provision of care and support in that way. And it must look at then considering the exercise of the power under the Town and Country Planning Act to specify accommodation use as a class. And also what it does is under clause 7, that's clause 9, sorry, there's an error there, provide that in relation to persons leaving exempt accommodation, those persons will not be considered intentionally homeless, especially if the accommodation does not meet the standards of accommodation or care or supervision under the National Supported Housing Standards. Next slide, please. So this 10 and 11 just provides for powers for regulations and use of information. Next slide. So finally, we have a draft bill that doesn't reflect the select committee report completely. It does some aspects of it. It looks at regulation, standards, and developing a regulatory scheme with a design to push rogue landlords out of it. But it's a private member's bill. So the question is, will it survive parliamentary scrutiny and time, given that there have been previous efforts to regulate this area that's gone nowhere? Will it make a difference to the problem? And MP's outrage, what you got from some of the reports, some of things that are written about, is an outrage from MPs. And the report itself is based on evidence from Birmingham and on the pilots. Is it a proportionate response given the minister accepts that this relates to a small number of road providers? That's the mischief. And the danger is, will it throw the baby out with the bathwater, that it's accepted that this form of accommodation is highly valuable for people, vulnerable people? Will this extra level of regulation and licensing and create a situation where it might dissuade bona fide providers, particularly from the private sector and other charities, to engage in the process? There's been some examination of the cost on the public sector, but no other form of impact assessment. So that there could be a danger that if it's too heavy, it could lead to loss of support from vulnerable people. And I've always wondered whether this is the correct mechanism of funding such care by preserving the use of housing benefit in this matter. So in the end, is this act proportionate to the perceived problem? Because that's what the minister talked about. Or can it be dealt with under existing legislation? And do those charged with the enforcement have the resources if the proposed act comes into force? There are problems with enforcement under the Housing Act 2004. There's stories all the time about poor quality housing in the private sector, where local authorities are not enforcing the existing legislation. And the question is the Act properly evidence-based, as it is, given the limits on the pilot and the limits on the evidence? So those are sort of pauses for thought that I have. It has to be remembered it's a private member's bill. It deals with some aspects of the concerns, but doesn't deal with all aspects of the concern that is raised by the Levelling Up Committee committee report.
Thanks very much, Tim. In a way, your final slide raises many of the questions that I hope are in people's minds as they listen to this talk. It's unusual to have a talk about proposed changes to the law. Normally, we're involved in disputes about how the law should be applied. We do have one question and answer that's come in through the chat. Feel free to throw in any more before we finish. And that was someone raised the question that if someone has just been issued with a license, what do we do if they're threatened with eviction? This was supported accommodation for young persons. My initial reaction was, oh, why would a supported accommodation provider be threatening someone with eviction? That should be the very last thing that they should be doing. If there's a problem with their accommodation, they should be looking for ways of finding more suitable accommodation. But otherwise, the licenses usually are written in such a way that they try and exclude any possibility of a tenancy. One piece of housekeeping that there is a feedback form, as always with these seminars, but it may arrive just after you get an opportunity to leave, but we don't let you escape so easily. We do send it to you afterwards. So feel free to put any suggestions on future talks or how this one could have been improved. Otherwise, the only question and answer are those left by Tim so far.
I just wanted to jump in there with the question posed by Andy Humphrey. Does the committee or the bill have any proposals to improve security of tenure? So at page 14 of the report, it says that the bill would give stronger protection to social housing residents who have license agreements, but they would not extend to licenses and privately rented exempt accommodation. And the report sets out the recommendations more clearly there. Maybe Tim can assist on what the bill actually achieves.
As I've read the draft bill, it says nothing about security of tenure in terms of, or improving it in terms of supported accommodation. The draft bill is a regulatory oversight bill, so it's to deal with the providers rather than the users, as far as I can see. And often the traditional approach to some forms of supported accommodation is to either have a sub-license or very limited forms of tenure. And I don't think that anything will happen to create tenancies under these new proposed regulations and statute, because the idea is that this is short-term accommodation to move on, and often one of the terms of a license will be that for the user to engage with the level of support or support that is provided, and such licenses can be terminated if people don't engage with that support. So I don't think it's going to improve overall, say for a limited circumstance in terms of social housing, the forms of security of tenure. That's not what the draft bill provides for. Whether there'll be further government legislation, I don't know, or whether the government will seek to amend this bill further.
Well, we already have a reaction, Tim, to your answer. That is from Cheryl Grant, that often young people are in supported housing for years.
Yeah, but you're not going to change the security of tenure.
Going back to the previous question, Mark Francis puts a finger on a very, very important issue, that because now we got universal credit alongside housing benefit, if the person is refused housing benefit, they're supposed to go off to universal credit, but then they got a dilemma that they think the accommodation is supported, exempt, so they should be getting housing benefit, but they're being told to claim universal credit, and many people are trying to avoid claiming universal credit for practical reasons. So I agree that it makes the position much more extreme, in that in the old days, if exempt accommodation was refused, the local authority would usually just pay basic housing benefit and you would have a dispute and an appeal. Now, often the person is receiving no housing costs at all while the review appeal process goes ahead, which can take many, many months. So it's making the position more extreme. Logically, they should be able to apply for universal credit housing costs without prejudice to housing benefit, but I can see that it just makes life much more complicated, and there's still many, many people on legacy benefits, and they will be there until 2008, it appears, from the latest government announcement. So no answer to that one.
I mean, is there a difficulty that if you cannot get housing benefit, then you can't get the benefit of the accommodation? Because if you're assessed, because under, I think what Georgie said in terms of the recommendations, there were proposals about amending the housing benefit regulations and also proposals about referrals. If there is a clear referral process, would that cure the problem in terms of accessing housing benefit over universal credit?
Well, usually they won't make a decision on housing benefit until you're actually an occupier. So there's a bit of a chicken and egg there. Anyway, we have another impossible question to answer.
Is from Springfield Law Centre. Should we seek to defend possession proceedings to avoid eviction for clients from supported accommodation where landlords might be alleging the property does not meet the decent home standards when where the client does not want the disruption of the move.
A sort of back to front scenario.
I think the problem is there that if it doesn't meet the national standards that they're purporting to bring in, so it doesn't meet the standard of housing, and it doesn't meet, and it may not meet the care and support matters, then the difficulty is then it's not going to meet probably the definitions or requirements under any new legislation to meet standards. And as I understand it, if they are evicted from that accommodation, they won't be determined as intentionally homeless. So I think it's that issue, you know, if it's a long-term home, firstly, it defeats the idea of temporary exempt accommodation. And in any event, I don't see how you could probably exercise a defence where the standards for that accommodation are not met, and probably housing benefit will refuse to continue to pay for that accommodation.
The next question is just unpacking the circumstances for that individual. It's where someone's currently not entitled to universal credit because their income from contributory ESA is too high. But that is just the same dilemma that if someone is offered supported accommodation, then it usually only works if they can claim housing benefit because the rent is usually so high. And the dilemma is you don't know whether housing benefit's going to be awarded because the local authority housing benefit team will look at each claim for exempt accommodation very carefully, especially in the light of this government, the mood music from government. And they may say yes or they may say no. And if they say no, one has to go through an appeal process where no housing benefit is being paid in rent, and rent arrears are being accumulated. And how patient will the landlord be? But this seems to be the scenario people end up in, that they need a decision on whether they come within exempt accommodation or not, because the local authority, based upon the information they've received, conclude that they are not entitled. And so a tribunal has to decide yes or no. There doesn't seem any way around that.
I mean, is it going back to one of the questions I raised, is whether the use of the benefit system per se is the appropriate means of funding these forms of exempt accommodation, given that you can have commission services from local authorities? Is there sort of a backwards way? We've got into this dilemma because the use of housing benefit has been the means by which this supported accommodation is funded, and it's a means tested benefit in itself. So if you have to meet a means test in any event, is it the wrong funding stream for such accommodation? Are we so invested in the use of housing benefit from this that we can't, or Parliament can't think of a better way of funding it rather than through benefits?
And it's become more of an anomaly as the housing benefits is gradually reducing. Housing benefit sections are closing down, and they're proposing to close it down for pensioners. And you're left with this small, very specialised staff looking at exempt accommodation. How do they retain staff? How do they keep their experienced members there? And the goalposts are now moving yet again.
But the question is it the wrong mechanism to fund it?
Well, I see no proposal of them changing that just yet. Of course, if they did, we'd set up another seminar immediately. Well, I think we'll run over time a little bit, but just to remind everybody that they're going to get the slides, they're going to get the recording, and they're going to get a chance to put in any feedback in due course. So though you can all click leave and forget about us for now, we'll be sending more information and looking for further responses if you think it's appropriate. But otherwise, thanks very much for our two speakers, and thank you for everybody for listening.